Today, we'll be talking about Nigerian legislation as the number one source of law in Nigeria. When we did the intro on the sources of law in Nigeria, we discussed that there are 7 main sources of law in Nigeria. And for now, we will talk about Nigerian legislation. Nigeria runs a federal system of government with tiers of government provided for by the Constitution, the federal, the state, and the local government. The federal government laws are made by the National Assembly, the Senate, and the House of Reps. Upon agreement, it is assented to by Mr. President. It becomes an act of the National Assembly. Under military administration, when it is assented to by the military head of state, it is called a decree. At the state level, when a law is passed by the state assembly, it is assented to by the governor. It becomes a law of the state, law of Rivers State, law of Lagos State, law of Sokoto State, law of Kano State, law of Bauchi State, and that. Under its military government, they used to call them edicts. And so, that's at the state level. At the local government, military never had any say. Laws agreed upon and assented to by the chairman of council is called a bylaw. All of these are the sources of law that fall under Nigerian legislation. But listen, there's a caveat. For every of these laws to be functional or to be called the law in Nigeria, it must agree with what the Constitution has provided. The Constitution delineates powers among the tiers of government. Powers that are exclusive to the federal government. Powers that are on the concurrent list. The federal and the state government can do them. And then powers at the residual level. On issues of defense, police, incorporation of companies, and all of that. That's why the State Assembly of the state cannot make CAMA, the Companies and Allied Matters Act, because the issue of running and management of companies is a matter within the exclusive legislative list, and the only arm of government that can make such laws is the National Assembly. Issues about chieftaincy title, who is going to be the Emir of Kano, who is going to be the Sultan of Sokoto, who is going to be the Oba of Benin, these are matters that fall within the legislative purview of the state houses of assembly. Then we have matters that the local government can deal with. They are little or negligible and all of that. All of this form local legislation. Any law that is formed outside of this arrangement does not agree with what is called the ground norm, the basic law of the land, the Constitution. That law is, to the extent of that inconsistency, void. Look at the decision in Attorney General of Abia State, Attorney General of the Federation. Look at the decision in Attorney General of Ondo State and Attorney General of the Federation. Look at the decision in Attorney General of Lagos State and Attorney General of the Federation. Of these decisions, you know that every law that does not conform with the laws as arranged by the Constitution is void.